pink headset, so I'm not going to do that.
Okay, we're live. I'm just gonna shut my window because I can hear the weed whacker. So 1 second.
In a few minutes, if you hear some screaming, it's my kids coming home from school.
Okay.
They're on the same bus, so.
Yes, that's right. I'll give you a heads up.
Hi, everyone. Thank you for being here. This is the April 13th meeting of the Municipal Code and Bylaw Committee meeting. I know that it's been a couple years since this committee has actually been able to get together ahead of town meeting. COVID sort of derailed that operational piece a couple years in a row, but I'm happy to be back here. This is my first time before this committee. So I am Becca Meekins. I'm the Assistant Town Administrator. I have been with the town since October of 2020. So started here right smack in the middle of COVID, and very happy that things seem to be, well, hopefully things improve with the summer. So we are going to get started. I do have Fred Litchfield here, who's the town engineer. He's going to speak to one of the zoning articles, the floodplain district article, and then Lori Connors is our new town planner. She is going to walk everyone through all the zoning articles, and then I will cover the personnel bylaw and just speak briefly to the citizens petitions. So to start, first item on the agenda is actually approving meeting minutes from 2019. They are in draft form. They've been on the web since then, but they haven't been approved because we haven't met.
Are there enough members that could approve it?
There are no members who are at the meeting are on the board. So I don't know how we can approve minutes of meetings when none of us were there.
Wait, for the Municipal Code and Bylaw Committee?
Yeah. Oh, were you there, Brian?
Sure. Yeah, I was there.
All right.
Yeah.
So I guess you can approve them.
Cool. Let me give it another quick skim. It's been a while.
Yeah, and just so you do know, the Attorney General has ruled that you don't have to have been present at the meeting. You just have to be a current sitting member, and at least one person has to have been there. So you could all vote if you felt we do want to get these sort of off the desk approved and up on the website. So I would appreciate that.
Okay.
Brian with his pink headset looks very trustworthy. So if
Thank you. Yeah, I'm making it work. All right. Sorry, I'm giving a quick skim right now. Okay, so do we have to do a full overview of it, or am I allowed to just say I approve?
I would make a motion and second it, and then you guys can take the vote. But if you are saying that what is drafted occurred, hopefully the committee will take your word for it, and we can get the vote squared away.
Okay, in that case, yes, looking through was drafted matches what I recall.
Okay, does anybody want to make a motion?
So I'll make the motion to approve the minutes from the meeting from 2019.
Second.
Any discussion? It's a roll call vote just because we're by Zoom, and that's the standard. So, Brian?
Yes, I approve.
Okay.
So it'll be I third.
Mitch?
I'll vote yes.
Okay, Andrea
Yes.
and Bill?
Yes.
Excellent. Thank you, guys. I appreciate that. Good to get that little housekeeping item out of the way so we can get started with the good stuff. So I'm gonna jump right into it. If everybody's okay with the format, I think I'd like to just go article by article if that works for you all. And so I'll do a brief presentation and then, or one of us will, and then you'll have the opportunity to ask any questions or any discussion that you want to have about that. So to get started, we're going to jump right into Article 22 this year is the Consolidated Personnel Bylaw amendments. This year, the modification is a little bit more significant than in the past because we just finished up a comprehensive classification and compensation review. So in June of 2021, we signed a contract with the Collins Center for Public Management. They're a consultant. They came out. They conducted a full review of our current plan. So that includes interviews with all staff who hold a position under Schedule A of the bylaw. It includes a full job description review, and it includes a market survey and for wages. So that was done between June and January. We have a final report from them, which I included in your packet. That final report and all of that work informs the update to the personnel bylaw, and it also informs the modification to the wage schedule in the bylaw. As you know, the wages for non-union staff are defined in the bylaw. They will always be, oh, Brian's joining us by phone. Hold on one second, let me let him in. Brian, I assume that's you.
Yes.
Okay.
Yes. Sorry about that. My Wi-Fi is spotty, so I decided to call in.
That's okay. Can you hear us?
Yes.
All right, great. So like I was saying, the full report and the work done by the Collins Center does inform the changes to the personnel bylaw this year that are being proposed under Article 22. Our non-union wages are they're formulaic in the bylaw, so they're the average of the union contracts. All of the union contracts are up for renewal this fiscal year. They're not settled yet, so we don't yet know what that wage increase is going to be for FY23 for non-union folks. So that is described in the bylaw itself, which is included in the packet to town meeting, and it will also be described in the motion that is made to approve Article 22. So people understand that there's not an increase on the table yet, and that's just a result of the formula built into the bylaw and sort of the timing of things. The only other thing I'll tell you is that on April 6th, the Personnel Board did meet. They were given a full presentation by the Collins Center and myself of the entire report, the plan, the process, and they did unanimously recommend that town meeting adopt what is being proposed under Article 22. So I'm happy to answer any questions you might have specifically about either the plan or the process, but I'm hoping that you all will also recommend adoption of Article 22. Yeah, Mitch.
First procedural question. Should we name a chair of our committee? I know this board typically
sure.
only meets every once in a while, but that's something I looked. I don't even think the past chair from 2019 is still a member. So
Yeah, sure. If you all want to elect officers, you're more than welcome to do that.
So I'll throw my hat in for Mitch to be the chair.
Because I brought it up, so it's my fault.
That's because you brought it up.
I
Yes,
second.
yes. Just trying to save the rest of us from here.
That's fine. Yeah.
Yeah, I'll support that.
Okay.
And do we need a secretary? I'll throw Brian under the bus if he wants to be the secretary.
I think it's more important that we have a vice chair.
Okay.
Yeah.
Brian being the last surviving member from last
Then let's-
season.
I think,
True. All right, I'll
Brian
take
is
vice
vice
chair
chair?
if I get the vote.
okay.
Hey, you guys, you gonna leave the secretary off the table?
I don't-
Yeah, I'll do your
I
minutes,
don't
Joe.
Yeah, I don't think we need it.
I don't think we need
Okay.
one.
All right, so I'll turn it over to you, Mitch, then.
Well, I'll turn it back to you.
Okay.
The only other thing, thinking about procedure, and I apologize for derailing the important discussion that we're actually here for. Should we read the opening statement about the governor's proclamation and the legislative continuation of that and so forth because we're meeting remotely? I think everyone has heard that infinite times, but we're a public body that if
Sure.
we're required to read that, we should.
Yeah,
I don't have that
you
in
know,
front of me.
I do, so I'll
Okay.
I'll read it just for the record, and I will put it on the minutes when they're
Yeah.
drafted, so people recognize that we were meeting remotely. And but okay, so pursuant to Chapter 20 of the Acts of 2021, an act relative to extending certain COVID-19 measures adopted during the state of emergency, signed into law June 16th, 2021. This meeting will be conducted via remote participation. No in-person attendance by members of the public will be permitted. This meeting will be live streamed, but will have no option for public participation. To view or listen only, visit the YouTube link posted on our agenda on the town's webpage.
Thank you, Becca. I appreciate that.
Sure.
Okay. All right. We were just about to start talking about Article 22. Becca, I think, did a great job describing it. I don't think either of the other two members of town staff have much participation on that. Questions? Okay, I don't see Brian, so I don't know if he's shaking his head like everybody else. I'd say my only question, when was the last time we did a reclassification? I know it was a while ago.
Yeah,
Yeah.
2005.
All right, so it's been, typically towns do these about every 10 years, if I
It
remember
should
right.
be every 10 years. It's
Yeah.
long overdue. The process actually began back in 2019, 2018, 2019. A consultant was brought on board at the time. They sort of started, and then the assistant town administrator at the time left. COVID hit. There were some other issues with the consultant, so it just never really came to fruition. So it was sort of the first thing on my to-do list when I I came here. So I'm really happy that we got it done, and the overwhelming feedback from the staff has been that it was collaborative, and I think there's a lot of appreciation that we got through it and were able to present this to town meeting this year.
Yeah, no, I've heard good things about it. And that the reason that I asked that duration question is there were a lot of changes in the reclassification. A reclassification always has a bunch of changes. It seemed like a lot. It makes sense since it's been 17 years since the town did one last time. So that answers my only concern about the volume of changes. So I'm good with it. If there are no other questions, I'll entertain a motion to recommend Article 22.
I will recommend approval of Article 22.
I'll
Second.
second.
I saw Bill's lips move before I heard Brian's voice. So motion made by Andrea, seconded by Bill. Roll call vote. Brian?
I approve.
Okay. Andrea?
Yes. Approve.
Bill?
Yes.
I vote yes. It's unanimous.
Right.
Thanks.
Okay, so just moving right down the list, Article 33 through 41, they're all zoning. So I'm actually going to turn it over to Lori, and she's going to just walk you through, an explanation of the changes that are being proposed.
Thank you, Becca. It's a pleasure to meet all of you. So, of course, I've been here for about 5 weeks. So I came in very, very late in the process of having these various zoning articles put together. So I will do the best I can with answering questions that you might have, but there may be some questions that I won't be able to answer because of my late arrival on the scene. But Article 33 has to do with Section 7-09-040 of the zoning bylaws. So that is the sign section. So there are a number of changes that are proposed within this section. The first changes had to do with adopting definitions for banner sign, flag, and roof sign. I'm sorry, modifying those definitions and then adding new definitions for externally illuminated sign, gasoline canopy sign, and internally illuminated sign. So it specifies that if pre-existing non-conforming signs, if they are legally permitted and erected prior to adoption of the changes, may continue as long as they are maintained, but they cannot be enlarged, redesigned, structurally altered, removed, or abandoned for longer than 30 days. And an abandoned sign essentially means that the tenant moved out or the property owner moved out and the business is no longer located at that site. So that would be an abandoned sign. So the article prohibits issuance of use variances for signs. I did actually ask for clarification from the planning board on what that meant. And what I was told is that there are certain signs that aren't allowed in certain districts. An example of that would be an electronic message center. So the only district where electric message centers would be allowed is the highway business district. So what this would do is it would not enable the ZBA to issue a use variance to allow, say, an electronic message center in one of the other districts. It also doesn't allow signs to be attached to roofs or gasoline canopies. It says where electronic message centers and internally illuminated signs are permitted, and clarifies that historic signs, markers, municipal plaques are permitted in all districts without a permit. So do you folks have any questions about that article?
I have some questions. It seems like the more we try to define what a sign is, the more convoluted it gets. And I'm only thinking of an example, which is probably minor in everything that we're trying to do here. But so we've added the word temporary to what a banner sign is. But just say an entity opens, and I hate to name someone on a YouTube video, but let's just say it's a bakery that opens in town, and they put a sign which now can't be attached to a roof, but it's a sign advertising their business. So it's a banner, but the intent is not for it to be temporary, because that's the only way they're going to advertise. How does that fit into helping small businesses advertise what they have there if they can't? So a banner is only temporary. They could have a flag advertising what they are, but it has to be on a pole. But if their only access to notify people or let them know that they're there is attaching it to a roof, then they're kind of prohibited from advertising.
All right, let me yeah, so yes, I mean, essentially what this says is that the banner is a temporary sign, and therefore it has to be up for a specific length of time. And I imagine that would be part of the permitting process. So when the applicant submits a permit application for a sign to the building inspector, that person will have to specify how long this banner is going to be up. So the banner cannot be utilized as a permanent sign. That is my understanding of these changes. So like if, for example, there was a building, there was under construction, maybe it was going to be revitalized, and they put a banner up on the building kind of celebrating the fact that this building was going to be utilized in the future for these particular types of uses. and they were advertising, spaces available, and it's on a banner, then that banner would have to come down once the period of time has been fulfilled.
Okay, and what if the only available means of advertising what this place is the roof? Now because of changes we've made or proposed changes, it says no sign shall be part of or attached to roofs. So now they have no way of advertising what they are.
Well, right now, rooftop signs aren't allowed. It's my understanding.
Oh, I thought anything that was underlined in these is something that was added. So specifically, I'm looking at D, basic requirements, number 3. So it looks like prior to these amendments that a sign could have been attached to a roof, because it looks like the word roof has been added.
I'll have to look at the zoning bylaw because I do believe that is already prohibited. But let me just double check. If you just bear with me a minute. I'm just getting to know the zoning bylaws, so I don't have everything memorized as of yet.
While Lori is looking that up, I have a question, Becca, or from pre-existing members. Does this committee try to wrap everything up in one meeting, or do we occasionally say, you know what, here's one that a little bit more discussion or research or anything else needs to take place, and we might need one more before town meeting?
And also, if I could just interject for 1 minute, and that is that the public hearing on all of these zoning related articles is going to be held on Tuesday night of next week. So there is the opportunity to present comments directly to the planning board at that time. So the planning board has not actually finalized these zoning bylaw changes as of yet. So if you have a specific comment, like maybe you suggestion for change, you can always bring that forward. And then of course, the planning board members who actually put together these warrant articles will be there to answer questions that you might have. But let me just finish looking that up, and I'm sorry to interject. You folks can finish that topic.
Page 105, Lori, at the top there.
Yes, I see it.
Okay.
No sign shall be part of or attached to marquees or awnings. Yeah, because I know that we actually just had a matter before the ZBA because somebody was interested in putting a rooftop sign on a building, and they were applying for variance because the building inspector had denied that request. Do you remember that, Fred?
I do. I think that there was a dispute over whether or not it was a rooftop or a marquee. I forget what Bob had indicated it was.
Okay. Well, I'll get clarification for you, and I can email you after the fact. I'll have to talk to Bob Frederico to find out exactly what the deal is about rooftop signs.
Okay. But it just seemed like the more we're trying to define what these are, it's getting more and more convoluted. And to answer your previous question, Mitch, it never seemed to take that long. I mean, this is an extreme example of something that's taking longer than, yes, we all agree. And in the past, we've been able to do it in, half an hour. So we've never had to have the need to go to another meeting.
Okay. Other questions or comments on Article 33?
None for me.
Okay, Bill, any questions or comments? Okay. Yeah, no, I thought what you brought up, Andrea, makes some sense. It would be good to have that answer.
So
I don't know if you're prepared or if we're prepared to vote on this, especially given that the public hearing hasn't taken place, and that's an opportunity we might hear other questions or concerns that we haven't heard about. Not that I want to change precedent and set a second meeting, but if we need to, we may need to do that.
But as I understand it as well, and Becca, please correct me if I'm wrong here, but the final warrant article is already in, right? So even if they were to change anything, it would have to be an amendment on the floor of
That's correct.
town meeting,
That's correct. The warrant's been posted.
right? So, I mean, even if anything does come out of that meeting, you know, it wouldn't change anything from now until town meeting on what's posted, on what's already in the warrant.
So I think because of this and that, you know, we're only giving either our recommendation or not recommend. It's not like we are voting on it. And I think personally, because I still have some questions, I could not recommend that we approve this. And I don't know how anyone else feels.
Okay. Any other comments on approving versus not approving? It's really recommending for, recommending
Right.
against,
Right.
or taking no position, or potentially waiting until we get more information and having a subsequent meeting. Any four of those is justified.
Yeah, I think there are so many questions about this, and this one has come up a lot in the planning board meetings. I know I've been watching them, so you know, just that one about the roofs makes me question whether whether I would really recommend this as written without the amendments. You know, if they were to make amendments, maybe my mind would be changed, but you know, we can only go with what we have in front of us. And, you know, there are still a lot of questions about what we have in front of us.
Brian, thoughts?
Yeah, just that I wouldn't want to be passing anything until we fully understand the subject. So I just agree that we should probably set this one aside for now. Well, set aside making any real changes.
Are you suggesting set aside taking action, or recommend?
I suggest not taking action.
Okay.
Just make no recommendation one way or the other.
Good. It is conceivable, Becca, I suspect, to have a subsequent meeting if we get enough information to then make a decision, even if that is immediately prior to town meeting, for example. My preference would be to make a recommendation on every article, yes or no, rather than saying we just didn't have enough information. If we don't have enough information now, that's fine.
But my concern here is that, like I said, they can't make an amendment until they're
Right.
on the floor of town hall.
Right. But we may get enough clarification to know whether we want to recommend or not on this article. It is also possible that if the planning board wants to amend, we might take a vote conceivably on not recommending the one that is in the warrant, but recommending the version that they plan to amend if we have the opportunity to see that in advance.
Okay, that makes sense.
I think I'm seeing consensus, and I agree on taking no action on Article 33. Is that
Or making no recommendation.
making no recommendations? I don't think we need a motion for that.
If the intention is to pass over it and come back to it, if we can set a later meeting date, I think that's fine. If the intention is not to provide a recommendation, that's a vote, that you're not going to make a recommendation to town meeting one way or the other. Those two things are not the same, in my opinion.
True.
No, I think I agree. At least from my point of view, I think we just, we hold off, we wait to see what comes of the public meeting. And then we can make make a vote at that point based on what happens.
Do we want to take a vote now on then making no recommendation, and then we could revisit that if we meet again before town meeting?
My concern is just, it seems like we're just passing over it
Yeah.
instead of, and I, you know, my recommendation would be against a recommendation on this article, if that makes sense, rather than just passing over it.
Any other thoughts one way or the other on that? My sense is that I know the planning board worked hard on this, and I know there's been a lot of discussion. Given the questions that you brought up, if there is a change that suddenly signs that used to be allowed, or banners, something for a new business particularly, used to be allowed and now is not allowed, and that's a realistic situation that could come up, I'd agree with you, but I don't know if I'm comfortable yet to go ahead and not recommend based on that, because I just don't know
Okay.
if we can get an answer. That's my sense. I'm just one of the four here. Bill or Brian, any thoughts?
Yeah, no, I think we just, like I said, I think we just wait until, you know, the public meeting and see what amendments they're willing to make. And then maybe we can make a recommendation based on, you know, the amendments that were spoken about in the public meeting.
I think the planning board would need to vote on an amendment that they want to offer for us to take action on it. And I don't know if they're going to do that at the hearing, and obviously we're rapidly nearing town meeting.
Yeah, I would just caution, so they can plan to make an amendment on town meeting floor. It
Right.
can't happen before that, and it has to be accepted by the moderator on town meeting floor. So you know, I would recommend against recommending any tentative new motion that they were preparing for town meeting until town meeting. Now, if you get to town meeting floor and, you know, they make a motion to change what's being proposed, and, you know, I mean, if you wanted to be prepared to make a recommendation there at town meeting, we'd have to post a meeting for this group to be there, which we can certainly do, but then you could opine then and there on that change. But I wouldn't do that in advance, because you just never, you know, you never know what's going to happen on town meeting floor. The moderator has a lot of control over what gets accepted and what doesn't. So that's all I'll say about that piece.
We may just have to make a vote on what we see in front of us.
Yeah.
Brian, any thoughts?
In that case, I mean, as cruel as it sounds, if we're not sure, you know, if we're against bringing in something that might be an unintentional ban, then I'd recommend against it, because they can just bring it back next year with clarity.
Right.
Yeah. My concern is I don't think we have a definitive answer on whether this is a new ban on something that was previously allowed, particularly along the lines of what Andrea brought up.
Well, I believe Lori looked, right, and there's nothing in the current bylaws about roofs.
You're muted, Lori.
Yeah, like I said, you know, I I have skimmed the sign bylaw, but I do not have it memorized by any means. So the building inspector, Bob Frederico, is really the one who implements the sign bylaw. So he's the one who is most knowledgeable about it and all of the aspects of it. So that specific section that you had asked me about definitely adds the roof to the language. So the original language that was there just had, go back to it. All all it said was no sign shall be part of or attached to marquees or awnings. That was the original language. So the new language includes the underlined text. So right now you can have signs on gasoline canopies. So this language would definitely make that something that is not allowed. So, and it also seems that this is the case for roofs.
Okay, so that seems to, I think, confirm your concerns, Andrea. Is that accurate?
Yes,
Okay.
yes.
Okay, so we may be prepared for a motion on that.
So I will make a motion against a recommendation against approval of this article as written.
Is there a second?
Second.
I second.
Okay. I heard Bill first, motion made by Andrea, seconded by Bill. Any other discussion?
No.
Roll call. We'll go backwards what I think is the order that I went last time. Andrea?
No further discussion.
Oh,
And against recommendation.
right. So are you voting yes on the motion? On
I'm
your
voting
motion.
yes on the motion against the recommendation.
Okay. Bill?
Yes.
Brian?
Yes.
I also vote yes. Okay, so we've taken action to not recommend Article 33. Recognizing, as with any of these, conceptually, if there's some change between now and town meeting and the opportunity for us to revisit it, we could, not necessarily that we would. Okay, thank you for the discussion on that. Article 34.
All right. So Article 34 includes definitions, 4 different definitions: brew pub, nano brewery, microbrewery, and the 4th definition is for brewery, distillery, or winery. So the article specifies the districts where these particular uses will be allowed, and it also sets forth the parking requirements for the uses. Do you have any questions?
So currently, would these businesses be allowed anywhere and just not have specific parking requirements?
Well, once again, that's kind of question for the zoning enforcement officer. Sometimes what will happen is the zoning enforcement officer, the building inspector, will find a use that currently exists within the use chart, and he will include the specific use within that category. So for example, brew pub, he could consider a brew pub a bar, and a bar may be an allowed use, and so then he would allow it to happen. If the way the zoning bylaw works, though, is if he does not identify an existing use as covering these category of uses, then it would be automatically disallowed. So the only way that these uses could be allowed would be to get a use variance from the ZBA. So it's all dependent upon how he would classify specific uses.
Okay.
So this is just a classification of those uses.
Correct. Correct. So if he would classify it as a use, like include it, like for example, if you look at our zoning bylaw, it has a category of use called personal service. And it defines what personal service is. If there's a use that comes in like hair salon, you can look at the definition and he can say, oh, okay, well, clearly personal service includes hair salon. So that's an allowed use. But if it's something that's a little bit more questionable, it's not specifically called out in the definition, then it would be up to him to decide whether he thinks it's appropriate to include it within that use or not. And if he says, nope, it's not appropriate, then it's a prohibited use. And the only way that they could go in would be with a use variance from the ZBA.
So this sets up that these types of businesses are very clearly allowed in town as long as they're in these districts.
Correct. So the inclusion of these definitions eliminates that question, that kind of fuzzy area of, oh, well, Bob classifies it this way, but if Bob were to leave his position next week and then we have a new person come in, we don't know how he's going to classify it. So it removes the question.
Thank you. Questions or comments from the board? No questions or comments. Is there a motion on Article 34?
Make a motion that we approve Article 34
I'll
as
take
written.
that as a motion to recommend Article 34.
Yes.
Okay. Is there a
I'll
second?
second. I'll
Okay.
second.
Okay. Motion made by Bill, seconded by Andrea. Roll call vote. Bill,
Yes.
Brian,
Yes.
Andrea,
Yes.
and I vote yes, unanimous in favor of recommending Article 34. 35.
All right, this article affects section 7-03-080 of the zoning bylaw. It spells out the enforcement procedure that the building inspector will follow when he receives written notification of a zoning violation. So it specifies the various penalties that he can assess against that individual or company. And examples of those penalties are revoking an occupancy permit, making a complaint to a court of competent jurisdiction for an injunction or a restraining order. Any questions?
If no questions, would someone like to make a motion?
I'm sorry, I'm trying to read this. I should have read it before. So is the real change that the building inspector is going to have authority to enforce or not enforce a violation? Does it all come down to what he wants to do, or are we taking that action out of his hand and making it mandate what he has to do?
So, of course, I've listened back and forth to Bob and the planning board discuss this article. And my understanding is that it spells out what he's already allowed to do anyway. The one concern that he has expressed at planning board meetings is the language that says that the building inspector shall, within 14 days, give notice in writing to the owner of the property or his duly authorized agent and to the occupant of the property, etc., of the violation. And I know that he likes to take a softer approach. So he prefers to have a phone call or do a site visit and have the first approach be that instead of a nasty gram. And so I know he has expressed concern about the word shall and preferred that it would be softened to say may. So I'm not sure whether the planning board is going to want to alter that language, or whether they just want Bob instead to just go straight to the written violation.
But my understanding is that there's a 14-day requirement for him to respond in writing, but in that 14-day period, Bob or whoever the building inspector is could certainly have the softer phone calls. And this then clarifies that you've got 14 days to sort of quietly sort it out before that written action takes place. And with that being a May, it kind of leaves it hanging.
Yeah, I mean, it
What I
leaves
worry
it up
about-
to his
sorry.
discretion whether he wants to send the violation within 14 days or whether he wants to make that 21 days or, whatever the time period that he wants to do it in. So that kind of instructs, the zoning bylaw instructs him what to do.
Brian, I think.
Now,
Oh,
yeah.
Sorry. Where are you all set or?
No, I'm all
Okay.
set.
Okay, Brian, did you have a comment?
Yeah, what I worry about is the strike through in section C, where we remove that the penalties start adding up after they're notified. The strike through area is each day that any violation is permitted to exist after written notification thereof by the building inspector / zoning officer shall constitute a separate offense. But we didn't replace that with the ability to give a phone call or something. Instead, we just replaced it with each day that a violation exists shall constitute a separate offense. So are we making it so that people are able to get fined without knowing that they've done a violation yet?
No. So this is if they refuse to comply. So my interpretation is that this is just kind of reworking the language that was already part of the zoning bylaw. So if you look below at the language that's stricken out, that provision is already in there. So there is already a fining mechanism. So the fine doesn't change. It's just, I don't know, wordsmithing, I suppose.
Well, I don't see anything about the fine changing. Yeah, just in section C, where they're removing the part where the fines start being applied after written notification's been given. And that's the part I'm worrying about. I'm looking around for a part where they mention when it starts instead.
Yeah, that language is already in there. So that's not additional language.
Yeah, and I think up in the top of that same section in section C, it says anyone who refuses to comply with the application, with the applicable provision.
Okay, cool. That works as a clause.
Right. So that's
All
your
right, thanks.
clause.
Yeah, that does it for me. I'm good then.
And I think in section B, I don't think the word shall is what the problem is. It's giving the building inspector, I won't say an out, but it does expand what he is allowed to do. Because the old version, it just says if he declines to act, he has to notify. And now it's saying that once he is informed of it, he shall make or cause to be made an investigation of the facts. So he does have the time, and then within 14 days, give notice. So we're not changing the shall language. I think it's giving him, that he has to do something. So instead of just saying, I'm not going to act on it, now we're kind of saying, well, why didn't you do something? And he's saying, well, I had an investigation and these are my findings. So I think the broadening is better. So I will put a motion forward if we have nothing else to discuss. So I will move to recommend approval of Article 35 as written.
For a second?
Second.
Okay, motion made by Andrea, seconded by Bill to recommend Article 35. Any other discussion?
No.
Okay. Roll call. Bill,
Yes.
Andrea,
Yes.
Brian,
Yes.
and I vote yes. Unanimously approved, recommending Article 35. And moving on to 36. Lori.
All right, so this has to do with the use variances in the zoning bylaw. It eliminates the zoning board of appeals power to issue use variances in any circumstances.
Could, if you know, because I know this has been dropped on your lap, I'd be curious as to a little background on this, as to how this came about, and is this common for towns to either have or not have use variance authority within the ZBA?
Well, my personal experience is, of course, right before I came to Northborough, I was working 16 years in the town of Millbury. And the town of Millbury does also have this power to issue use variances. So I had been told at some point that there were only 2 Massachusetts communities that with this power, but I don't believe that to be accurate because I know of more than 2 communities myself. How this came about is that certainly when you attend planning workshops, there are planners who don't like use variances because they feel that they are kind of a free pass from the way zoning is written in a community. But then there are others who see the benefits of a use variance, like, for example, what we were just discussing a minute ago having to do with breweries. If the building inspector said, no, I can't include this within any of our allowed uses, so it's not allowed, then the brewery wouldn't have the option of applying for use variance and being permitted that way. So there are plus and minuses arguments with this particular article. I know that planning board members have mentioned at the meetings that I have attended, and also, behind the scenes, the Northborough crossing variance that enabled that project to go in was perceived by certain individuals as being improper use of the use variance. So that might be the motivation behind this article. They feel that it's more appropriate to go to town meeting and get a property rezoned to allow a particular use than to have a small group of individuals to have the power to make that decision.
I'm curious, Fred, I know this isn't officially your article, if you have any background on this to help us out a little bit.
Well, it's not my area, but I have been here. As Lori indicated, it's really kind of an opinion that people will need to weigh in on. The Zoning Board of Appeals feels as though it's a valuable tool that they have to work with applicants in some certain circumstances. And some residents and board members of both the planning board and the ZBA have pointed out use variance having been granted to the Northborough Crossing project, and the ZBA issued that use variance and felt as though it was the appropriate thing to do because it allowed something to happen that might not otherwise have happened without going to town meeting. And then there is the other side of the coin where people feel as though it should have been it should have been presented to the voting the legislative body at town meeting. It depends on how you feel on that. I think there's far more instances where the ZBA uses that power to move something forward that otherwise might not go forward at town meeting. And I think it's a tool that they have in their toolbox that they prefer to have. But again, it really is how you come down on what how much should go to town meeting and be voted on by the town.
Yeah, I mean, you could certainly make the argument of why have zoning and use categories at all if a small board could decide anything. And I know the zoning board wouldn't make decisions like that arbitrarily. I wish there was a halfway.
I mean, it comes down to your opinion of the ZBA's implementation of that tool. I believe the ZBA feels strongly that they've used it sparingly and appropriately. And some people have in the planning world, and Lori can attest that there are some communities that absolutely will not allow any use variances under any circumstances. And it just depends on where you come down on each side of that argument.
Lori, I'll get to you, Bill, in a second. Lori, do you have any insight as far as how strongly the planning board believes or why they believe that this is necessary? And if you don't, because you're new to this, that's okay.
I believe that probably 4 out of the 5 members will recommend in favor of the passage of this article. So one member has expressed that she's not a big fan. So I don't believe that it'll be a unanimous vote.
Okay. Bill, you had your hand up before.
Yep, thank you. Lori, real quick, are you aware of any towns in the area that that prohibit use variances?
Yes, there are a number of towns who prohibit them. I believe, of course, I haven't done a survey, so I can't say off the top of my head, but I believe Sutton is one of those communities that doesn't allow it. So they're an abutting community to the town that I live in. And they recently went through a very large zoning change to permit some industrial warehousing type uses as well as residential uses in an area where they were not previously permitted. So that is the avenue that they go through. I did also work with the town of Groton, and they did not allow use variances. So if folks were interested in changing the zoning for a property, then they would have to go to town meeting and have that approved. It can be a heavy lift because it could mean, especially if you're a community that only has one town meeting a year, if there's an applicant that comes forward in June and they're interested in doing something and it's not an allowed use, then they have to wait almost an entire year to see if the town is going to allow them to go forward. So that can be a deterrent for a particular type of development. They may decide, well, I'm not going to wait a year. I'm going to move on to another community. So there is a risk, but it all depends. There's no right or wrong answer. There is an avenue both ways for a project to get approved. When you don't have a use variance, you have to be very mindful of spot zoning. So if there is a particular parcel of land, maybe it's 20,000 square feet, and they're interested in rezoning that from, say, residential to a business use, well, that could be considered spot zoning. And so typically what I like to see is an expansion to include at least 3 or more properties. So then you can't be accused of spot zoning, but then that's going to impact the neighboring properties as well.
Right.
So,
but you could also make the argument that that a use variance is essentially the same thing,
right,
as spot zoning.
Yeah. So my point was, my point was that this isn't illegal as far as the state is concerned, right? Prohibiting use variances. So from a rules and bylaw committee perspective, right? If this is what the planning board wants to do, is there a reason that we could deny it because of, either something in the writing of the bylaw or something in the, actual application that's against what, the state allows? And it doesn't sound like either of those is the case.
No, and this has already been vetted by town council. So the way that the article is written is perfectly legal. So I don't anticipate that the Attorney General will toss it out if approved.
Other comments or questions? Sorry.
I have a quick question. In order to apply for a variance, aren't there certain criteria that you have to meet? Like the only one I'm thinking of is a hardship or something else. So you're requesting this variance because there's no other way to get what you want. Is that my rudimentary understanding of that?
That's up to interpretation. So of course it's written, if you look at land use law, there are very narrow requirements for the issuance of a variance. So it has to do with soil types and topography, and there's a third one, but it's conditions that apply to this parcel that are not, don't apply to parcels within the same vicinity. So many zoning board of appeals don't abide by those requirements. And so if an appeal of the ZBA decision is filed, then it's up to a judge to determine if the ZBA followed the letter of the law or whether they didn't. Generally, I have seen many instances, not necessarily in Northborough, because of course I'm new to the town, so I don't have the background in how use variances are issued in Northborough. But I would absolutely say that in the town of Millbury, the use variance has been abused in the past. But that doesn't mean that it can't be properly applied. So if, for example, I'm going to give you a perfect example. So what if you have a historic mill building that is located in the middle of a residential area? And this historic mill building has been utilized as a mill building for, decades. And then say it is abandoned for a period of, say, 2 years. And then somebody wants to reactivate that use. If there is no use variance eligible, then they won't be able to use it for that way. So if it's in a district that only allows single family homes, then this 7,000 square foot or 10,000 square foot mill building couldn't be anything except a single family home. Well, that isn't a real appropriate use for a 10,000 square foot mill building. So chances are that mill building would just fall into decay and it wouldn't be utilized, or it would have to be demolished. So an appropriate use of that power would be, okay, here, I'm going to give you a use variance and you can reactivate the industrial use. That's just an example.
But that would only come into play if the building was vacant for 2 years. So
correct, because you lose your grandfathering if it's been abandoned for 2 or more years.
And as you said, the applicant would always have the option of requesting going through town meeting. And even though Northborough does have town meetings generally only annually, for a substantive or important project, a special town meeting could be scheduled either by the Board of Selectmen or by petition.
Correct. So
Yeah.
they could go to town meeting. So let's pretend this is a 2-acre parcel of land. So they could go to town meeting to rezone this parcel of land for industrial purposes.
Mhm.
So that is an avenue that's available.
Right. And you said that with the towns that don't allow use variances, that's the process.
That is the process, yes.
Yeah. Okay. Other questions, comments? From my own perspective, it's a big change, but I think overall something like this makes sense, so that hopefully we would then pay more attention as a town to the uses allowed in districts and update those readily, as opposed to relying upon a use variance process. But I see the concerns both ways. If there are no other comments, would someone like to make a motion?
I move that we recommend Article 36.
Is there a second?
I second.
Any other discussion?
I am against the recommendation for approval.
Okay. Any other comments? Andrew, do you want to elaborate upon that?
I do. I just think, allowing the ZBA to listen to a potential buyer of a property. And again, I believe there are certain criteria that they would have to meet. So this is not just willy-nilly, a developer came into town and it's in a single family, or we can only now allow two-family dwellings on X number of acres. I've lived in Northborough almost 57 years, and the change is, I won't say it's favorable, not really friendly to small businesses, not really friendly to the one person or the 5 people that want to do something. So I think the ZBA, I would like to still allow them to be able to make those decisions, rather than have a planning board that really doesn't know my neighborhood or my concerns or anything like that, to be making these decisions for the town. That's just my personal opinion.
Any other comments or questions before we vote? Brian? So this is a motion on recommending. Brian?
Yes, I recommend.
Bill?
Yes.
Andrea?
No.
I vote yes. Vote carries 3-1. Thank you. Article 37.
All right, so this is a change to the zoning map. So this is rezoning a specific parcel of land, 37 South Street, which is on the border between 2 different zoning districts. So the idea, I guess Becca is going to share. So you can see right now this district is zoned yellow, and the proposal is to rezone it so it's included within the blue area, the downtown business district. So the yellow district is the residence district. So right now, this property is occupied by a number of commercial tenants. So it is a non-conforming use. So by rezoning that area, including it in the downtown business district, it would be a conforming use.
Do we have any information if they plan to keep the property, the same? Like if we pass this thinking that they're just going to finally be conforming, do they have the ability to pull a fast one on us and put up something, knock it down, put up something bigger, since the lot is now a different use case?
Well, right now, from what I understand, it used to at some point be a residential use, but it has been used as a commercial use for many, many years. So I Are you asking if the building can be knocked down and expanded?
Yeah, I'm asking if when we rezone it, would that give them the ability to do that, or would we just be approving this and it would let them stay conforming, with the current stuff that they have?
I suppose that they could alter as long as it's in conformance with the zoning requirements for the downtown business district. So I don't know the particulars about this building. Like, I don't know exactly the size and the setback requirements and the number of parking spaces. I can get that information and report it to you. I just don't know off the top of my head.
That's all fine. I just I walked by it. It's like it's like a 1-story building. It looks like a kind of like a longer ranch house. It's got like 5 parking lots. It's across from a small park. I walk by it all the time. I was just seeing if we were able to get. I guess we wouldn't be able to, because once it's zoned, they could do whatever they want in that zoning parameter. Yeah, I suppose I'm for something like that. I just hope that they don't, pull a fast one on us and throw up like a 3-story something right across from the small park.
No, so that particular building has actually been a law firm for many, many years. And from my understanding from the previous, and Lori, please correct me if I'm wrong here, but my understanding was that line that you see on the picture, Brian, I don't know if you can see it or not, but it went straight through the property. So when they moved it back many years ago, they moved it in the wrong direction. And so every time a tenant came in, he had the gentleman who owns the building had to get a use variance.
That is my understanding of the history, is that originally the line did go straight through, and then they changed it.
So he just wants to.
Yeah, then I support this.
Other
All right,
comments or questions?
I have no further questions.
Okay. Any other comments or questions? If not, I'll entertain a motion.
I motion that we pass, or that we approve.
Okay, that we recommend. I'll take that. Is there a second?
I'll second.
Okay, motion made by Brian, seconded by Andrea. Any other discussion? Okay, let's see. Bill?
Yes.
Andrea?
Yes.
Brian?
Yes.
I vote yes. Okay, we are recommending Article 37. Article 38.
So the next article is a housekeeping item. So a number of years ago, duplexes or 2-family homes became special permit uses. Originally, they were by right uses. And the language in the exceptions category under site plans still had 2-family dwellings as a by right use. So this would correct that, so that if a duplex is proposed, it would also be subject to site plan review.
Questions, comments?
Yeah, I'm familiar with the concept of site plan review. Sorry, I'm looking it up right now. Okay, all right, yeah, no questions.
No other comments or questions? I'll entertain a motion.
I move that we recommend Article 38 as written.
I'll second.
Okay, motion made by Bill, seconded by Andrea. Any other questions? Brian?
I vote yes.
Andrea?
Yes.
Bill?
Yes.
I vote yes. We are recommending Article 38 unanimously. Oh, my dog does too. Article 39.
So Article 39 would create a temporary moratorium on distribution and transportation uses. So the idea would be to create a 5-person committee to study the impact of these types of uses and report its findings and recommendations to the planning board by January 1st, 2023. The moratorium would expire on May 1st, 2023. And the idea is that the planning board would possibly submit some changes to the zoning bylaws for town meeting consideration 1 year from now.
Any questions or comments?
I have just one. When it mentions, making the 5-person committee, is there any budget assigned to that, or is it just going to be a volunteer setup?
Volunteer.
Okay, yeah, I have no questions.
I know that large warehouses are an issue, not just here in Northborough, but everywhere. And I know that the planning board wants to take this step as a way to study this a little bit more thoroughly than they've done thus far, as reflected in Article 40, which we'll get to in a minute. Okay. No other questions?
I'll make a motion to recommend Article 39 as written.
Second.
Okay, motion made by Andrea, seconded by Brian. Any other questions or comments? If not, Andrea.
Yes.
Brian.
Yes.
Bill.
Yes.
I vote yes. We are unanimously recommending Article 39. And Article 40, speaking of warehouses.
So Article 40 would be passed over if Article 39 is accepted. And so Article 40 modifies the definition of warehouse and adopts new definitions for fulfillment center, package freight delivery facility, and delivery station. So the article also specifies that these 3 types of uses, fulfillment center, package freight delivery facility, and delivery station, are prohibited in all districts. So the planning boards, they're essentially hoping to see how things go. And possibly during study of these uses, they may decide in the future to allow certain uses in certain districts. But right now, they just want to get the definitions in there and say that they're not allowed anywhere.
So our recommendation on this would only apply if Article 39 did not pass, correct?
Correct.
Okay. So for this, I guess we assume that Article 39 did not pass, and then town meeting is taking up Article 40. And any questions or comments on Article 40? Okay. No comments or questions. Is there a motion on Article 40?
I move that we recommend Article 40 as written.
I'll second.
Okay, motion made by Bill, seconded by Andrea. Any other discussion?
No.
Okay, vote. Andrea?
Yes.
Bill?
Yes.
Brian?
Yes.
I vote yes. Article 40 is recommended unanimously, condition on it actually going to a vote. Article 41.
I'm going to defer to Fred on that one.
Thanks, Lori.
Thank you.
Article 41 is a rewriting of the floodplain district overlay. The state Department of Conservation and Recreation oversees the floodplain management for our state in accordance with what the Federal Emergency Management Act requires them to do. They have asked that we rewrite our bylaw to make sure that it has the proper language to make it meet conformance with the FEMA regulations, and in order to have the citizens of Northborough who require floodplain insurance, flood insurance, this would allow us to keep current. The bylaw has been drafted in accordance with the guidelines given by the state floodplain coordinator. It's been approved by them, and it has seen, it's been reviewed by town council, who's also done this for a number of other communities within the Commonwealth, and it's recommended, it's now being presented to the town meeting in order to allow the residents who need flood insurance to maintain that going forward.
Any comments or questions on Article 41?
Just that for one of the bigger ones, this one looks pretty more straightforward. I mean, it's mostly to meet compliance and approved by a couple different groups before it even got to us. So, you know, as much as it is a lot of reading, this one looks like one of the easier ones to approve.
There's really not much wiggle room in that. We've been asked to adopt something in accordance with their guidelines. We've written it to meet those guidelines. They said it's okay. I don't really have the room to make a change and still keep it in compliance with what the guidelines have indicated for us. So I wish it was shorter, but it's not.
That's all good. I agree. It looks, you know, it's everything that we need to have it be. In fact, I mean, if there's anything else, I'd make the motion right now to recommend.
Okay. Is there a second?
Second.
I will second.
Okay, I'll give the second to Bill. Motion made by Brian, seconded by Bill. And let's see, Bill, you haven't gone first in a little while.
Yes.
Andrea?
Yes.
Brian?
Yes.
Okay, and I vote yes. We unanimously recommend Article 41. And I think that does it for everything except for a couple of petition articles. Is that correct, Becca?
That's correct.
Okay. So Lori and Fred, if you want to stick around, you're welcome to stick around. If you want to depart, you can depart. But either way, thank you very, very much, both of you. And Lori, great meeting you virtually. Hope to see you in person sometime.
Thank you. Great meeting
You're
you
welcome.
all.
Yeah.
Thank you.
Nice to see you all, and you're very welcome. And if there's any questions that come up on the floodplain bylaw that get transferred to you, please send them my way. Thank you. Good afternoon.
Thanks. All right. So Becca, we've got a Article 42 on the holding of town meeting.
Yes. So Articles 42 and 43 are both submitted via citizens petition. Article 42 is proposing modifying the town code to move annual town meeting from its current date, which is fourth Monday in April at 6 p.m. to 10 p.m. To Saturday in April. This has come up before. A few years ago, there was talk about potentially moving town meeting to Saturday. It was somebody had requested that the board look into it. And it seems through my reading of minutes and discussions that the compromise that was reached at the time was to move the start time of town meeting from 7 to 6 to make it a little bit easier for folks. And so that it doesn't go as late, and that was approved at town meeting when it was put forward in 2019, I believe. At that time, I do believe that this committee supported that article moving forward. In 2019, when that discussion was happening, the staff did some research, discussed with other communities in Massachusetts. The overwhelming majority of communities do still hold town meeting on a weekday evening. There are a handful that have moved it to Saturday. There are, the concerns that have arose through my discussions with Andy Dowd, the town clerk, who's actually outreach to those communities and had those discussions. Saturday tends to be, for families anyway, it's a busy day, particularly if you have kids who play sports. And so it can be challenging. Obviously, the flip side is that if you have young children, coming out on a weekday evening can be challenging. So, all in all, I think it's, there are going to be challenges to both. One thing that was brought up more recently is that Saturday is the Jewish Sabbath, which, we would never consider holding town meeting on a Sunday. So why would we consider holding it on a Saturday? So that's certainly something to consider. And, the anecdotal feedback from my discussion with Andy is that moving town meeting to Saturday doesn't increase participation. Participation is largely driven by what's on the warrant. And if you're interested in what's on the warrant, you will find a way to make it to town meeting. So that's sort of like, that was all packaged up and delivered to the board back in 2019, which I think is why the compromise was reached. Obviously, this was put forward again this year as a citizen's petition, but it's really, it's opinion based. It doesn't really cost more one way or the other. Staff have to show up, whether it's in the evening or it's on a Saturday, so that it's really largely whatever you think is makes the most sense for the community.
Comments or questions? Bill?
So I guess what my concern here is that the change we made was in 2019, correct? So that was right as COVID hit. So we really haven't gotten a good idea of whether that change will make a difference or not, to be honest, right? Participation has changed over the last 2 years, no matter anything you talk about. So while I do agree with the idea of, moving it to Saturdays, I still want to see if, just changing the time increased participation. Right. So I don't know if I think it's a good idea. I just don't know if it's the right time. That's my comment.
I would have to agree with Bill. I think without really seeing what it is, because I could go either way. I mean, everyone's busy during the week, but Saturday, kids have to be here and it's busier. And I totally agree with what Becca said, that, attendance is driven by what's on the warrant. People are going to show up if they want their voices heard, if they want to do something, regardless of what day it is. So I think without having more data to show if it's feasible that, oh yeah, we have, a 20% increase if we do it on a Saturday than if we do it on a Thursday night, I think it's premature at this point to do something.
Yeah, I tend to agree with the comments that have been made thus far. In the town where I used to live, we had our annual town meeting was on a Monday evening, and we tried one special town meeting on a Saturday with a thought of increasing participation. I think it was particularly among parents, who the main article for that special town meeting was going to impact, and it didn't seem to make a tremendous difference. I would love to see more people participate in town meeting. You'd never really have enough unless you run out of space, and then you find a way to deal with that. And that's not, hasn't been an issue in the years I've been here. So that, other ways of increasing town meeting turnout is outside the scope of what this board does, or outside of this article. So I tend to agree that we should keep it as is. Are there any other comments? I'll entertain a motion.
I make a motion that we do not recommend Article 42 as written.
I will second that motion.
Motion made by Bill, seconded by Andrea. Any other discussion? All right, Brian.
I vote yes. Well, yes, for their recommendation to not recommend.
Bill.
Yes.
Andrea.
Yes.
I also vote yes. So unanimously, we are recommending to not approve Article 42.
Okay.
And then we had the Brave Act article, which I'm having a hard time finding that in my memo.
Yes. So the Brave, I believe there is so I provided a cover memo So Article 43 is also a citizen's petition for the town to adopt the BRAVE Act, which is a full property tax exemption for Gold Star parents, parents whose children have been killed in the line of duty. This warrant article was proposed last year by the Board of Selectmen. It did fail last year. I did forward the link to the meeting. There was a pretty healthy discussion, I would say, at town meeting last year about the article. It did fail, and it was brought forward again this year by citizens petition. Just a quick overview: the full property tax exemption for Gold Star parent is for any parent or guardian living in town who owns property. There is no reimbursement from the state. So many veterans benefits, Chapter 115, some of the other exemptions that we offer through the assessor's office, they do have a reimbursement that is attached to them from the state. So this particular exemption, if we were to adopt and offer, we would not get any of those funds back from the state. So that's something to consider. In terms of just looking at other towns and communities, we are a member of we are part of a 4-member veterans district. So we have a veterans officer who also serves the town of Grafton, the town of Westboro, and the town of Shrewsbury. We make up the Central Massachusetts Veterans Services District. We are the only community who has not adopted the BRAVE Act in the district. So that's just something to consider. Overall, there are 2 other exemptions that are for veterans, spouses, or surviving spouses of veterans, Chapter 22 and 22E, and Chapter 22D, both of which are currently offered by the assessor's office. One is a full tax exemption that is for a surviving spouse of a veteran who has died in the line of duty. And the other one is a partial exemption for disabled vets or spouses. And those are currently offered through our assessor's office, and they do require application. And we do have people who are currently receiving those benefits in town. In terms of the ability to know, I think this was asked at town meeting, but is there a way for us to know how many people will qualify for this in town? The answer is really no. The state doesn't provide a lot of detail with respect to veterans and benefits to individual municipalities. So it would just depend on who applied that year. And there are people who qualify for benefits that choose not to apply. So there's really no way to know exactly what the financial impact would be to the town. But, overall, I think it's certainly worth considering.
There's a nonprofit in the state that supports families of those who have been killed in the line of duty, and I believe the director to that organization happens to be a Northborough resident. I spoke with her at some length about this, and her understanding is there is one family in Northborough that would be eligible for this benefit. She's not aware of others. That doesn't mean that there are others, because not everyone takes advantage of the organization that she helps run. And it doesn't mean that at some point someone may qualify, either due to tragedy or due to moving into town. The other thing I learned when reading a little about this is that every town that this has been presented to has approved it, with the exception of Northborough. I believe we're the only town last year that did not approve it.
And as I read the act or what was presented, there is a requirement that they live here for 5 years prior to qualifying. So it's not like, oh, yay, let's go to Northborough because they just approved this, so we don't have to pay the taxes. It's kind of shameful that we're the only ones who haven't approved it, but let's fix it.
Any other discussion? Is there a motion?
I will make the motion to recommend approval of Article 43 as written.
Second.
Okay, motion made by Andrea, seconded by Brian. Andrea?
Yes.
Bill?
Yes.
Brian? I also enthusiastically vote yes. On this, we will unanimously recommend Article 43. Becca, am I correct in my notes that we've reviewed all of the articles?
You are correct.
Thank you very much. Procedural question. Does it fall upon me as chair to let town meeting know of our recommendations, or do we rotate around? I'm fine either way.
So I haven't been here yet for a municipal code and bylaw recommendation town meeting. I would say that as chair, that is likely your duty. People will certainly, if people wish to know your stance, they will call upon you. And it is good for the committee just to have an understanding of what's being proposed, because I've heard that in the past, people have asked the committee's stance in considering various articles at various town meetings. So yes, I would say yes.
Okay. Yeah, I think in years past, I agree, it has been valuable to hear the committee's position on the bylaw articles, just like it is important to hear from appropriations recommendations on financial articles.
Yeah. So I will draft up like a little a sheet that has the list of the articles that were considered today and the subsequent votes. So that will be available to town meeting as well. So people will have that as a reference document.
Fantastic. Appreciate that, Becca. I don't think we have any other business. If anyone has any other items to bring up, now's the time. And it sounds like we do not need to schedule another meeting before town meeting unless we get some additional feedback on something. If any members or staff think that it's worthwhile to have another meeting for any reason, we'll do that. In which case, I'll entertain a motion to adjourn.
I'll make a motion to adjourn.
I will second.
Motion made by Bill, seconded by Andrea to adjourn. Brian?
Yes.
Andrea?
Yes.
Bill?
Yes.
I also vote yes. We are adjourned at 4:07 p.m. Thank you very, very much, Becca, for putting this all this good information together. And thank you very much for the entire board for participating.
Thank you.
Thank you.